Good morning, History 259. I hope you're well. It is officially week 13 of our semester, about a little bit more than a month into online corona learning. So I hope you're all doing well, and that everybody continues to be safe. So a couple of things before I talk about today's topic, the Constitution. First of all, I emailed some of you about this. Was feeling a little bit under the weather over the last few days, going back to late last week, not corona related, something else. So I'm going to finish grading your midterms, or I'm sorry, not your midterms, your second primary source paper by tomorrow. You'll have those grades. I'm also going to post the prompt for the final essay for the course, which is due, as I say, on the amended syllabus on May the 20th. What I might do is give you a couple of extra days to finish that, make it due the 23rd of May, because I'm a few days later than I intended to be in terms of getting you the prompt. So this will all be explained in an email that I send out to you later this week. As I also sent it in an email, I was having some tech problems on Monday, so I couldn't record this, so we're watching it today. I'm going to post a discussion response. You'll have until the end of the weekend to finish it, so you have from today, which is Wednesday, the 22nd, until Sunday, the 26th to finish it, so you have plenty of time. And this one will be, again, relatively short, and it sort of caps off the subjects of the last 2 weeks, the previous 2 weeks, which are the critical period, right? So as you remember, this discussion of the 1780s, I think, really upends a lot of the popular understandings of what the state of the early American nation, the social and political and economic problems that faced it. And so last week we talked about, for example, the weaknesses of the United States in the 1780s as it referred to internal elite conflict or class conflict between elites and sort of common Americans. That was a major theme. And we sort of built up to what we're going to talk about today, which is the creation of the Constitution. And I hope this is made clear, it's certainly made clear in Alan Taylor, American Revolutions, but I hope as we made clear over the last couple of weeks, the creation of the Constitution was not necessarily a glorious event, certainly in the way that it's often thought of now, but in many ways one can think of it as a last-ditch attempt to save the United States. And that's how I think is the most productive way to think about it, because it should be clear that the early United States in the years after achieving independence was extremely weak. Certainly the national government was weak. We talked about that 2 weeks ago with reference to the Articles of Confederation, but that there were internal conflicts in addition to external threats that made the early United States very vulnerable to falling apart. So again, in this context, the Constitution is, again, we could think of it as a last-ditch attempt to save this country being the United States, from falling apart. And that's the context in which we should think about it, rather than, again, being a stroke of brilliance created by elite white men that we should venerate, which isn't to say that we shouldn't respect the Constitution, of course, but that in the context in which it was created, it came from a place of weakness rather than a piece of strength. And so what I want to do today is talk just a little bit about the Constitution itself and really focus in on, excuse me, a couple of issues pertaining to slavery. That's going to be the main theme of the talk today. And this corresponds, by the way, if you have Alan Taylor, American Revolutions with you, to the very end of actually last week's reading. So that's pages 374 to 383. So I'll be pointing to a couple of passages here from the end of this chapter. And then, as you know, just looking forward next week, and you know this because it's on the updated syllabus, we'll be reading the next chunk of Alan Taylor, American Revolutions, a chapter called Partisan. So I'm going to just engage with the very end of the last week's reading, and then I'll talk about, and you can pull up on Blackboard, a couple of sections of the Constitution. There is a link to it on Blackboard, which has been there since the beginning of the semester. So if you can, go and pull that up now, and you can just have that ready to go for when we get to that point in the discussion. Gotta have coffee. Okay, so if we think about the Constitution, again, as a sort of what's the right word for it? I keep using the word last-ditch attempt, so maybe I'll rephrase it and say, as a Hail Mary, there we go, to use a football metaphor, a way to prevent the United States from falling apart. We've talked for the last 2 weeks about the context. I just want to make a couple of points very clear from the outset here, in terms of understanding the process that of the creation of the Constitution, and then the provisions of the Constitution, which we'll talk about at the end of this, which I'll talk about at the end of this video. And I've repeated the first point, that the Constitution was an attempt to save the United States. The second point, and this is a point that's made in Alan Taylor's chapter called Republics, beginning on page 374 and 375, that the delegates to the Constitutional Convention, which met in the summer of 1787 in Philadelphia, were themselves drawn from the elite class. And that's a really important point, elite classes of the United States. That's a really important point to keep in mind as we discuss what was created, the government structure that was created in the Constitution. Because there are, in many ways, you can interpret the Constitution as an attempt by elites to create or reform a government structure that had failed, the Articles of Confederation, into something more powerful that, if we think about it in class terms, would preserve the power of elites. And who were these elites? They varied by region in terms of their background and their occupation or the source of their wealth. But I'll just pull a quote from page 375 out to describe who these people were. This is coming from the middle of the page. Excuse me. Most of the early United States quote-unquote great leaders did attend the Constitutional Convention, with only a couple of exceptions, which Taylor notes. John Adams, John Jay, Thomas Jefferson did not attend the Constitutional Convention. John Adams and John Jay were in England for diplomatic duties. Thomas Jefferson in France, nor did Thomas Paine. Alan Taylor doesn't include Thomas Paine, but obviously I will. Those four men were not at the Constitutional Convention, but everybody else was, all of the sort of major leading lights that we would associate with the quote-unquote founding generation, founding fathers, George Washington, Alexander Hamilton, and on down the line. There were 55 delegates, as Alan Taylor mentions, and just to pull out a quote from just about below the middle part of page 375, saying that professionally, in terms of their professional backgrounds, they were a mix of lawyers, merchants, great planters, meaning large slaveholders who owned plantations in Virginia, Maryland, North Carolina, South Carolina, and Georgia, and landlords in the northeastern states. 25 owned slaves. So to think about that mathematically, a little less than half of the delegates to the Constitutional Convention were slaveholders, 25 out of 55. So that's about 45%. And that's a point worth remembering, especially when we get to discussion of slavery in the Constitution. So knowing their social backgrounds and their another way of saying that is their class backgrounds helps us understand what was created in the Constitution. As I said, the second major point is that this was a document, a government structure that was created by elites, slaveholders, great merchants in the Northeast, etc. In many ways so that they could preserve their power. We talked about it and you read about threats to their power in the 1780s in the form of rebellions like Shays' Rebellion, for example. So that's a really important point to just keep in mind. I want to transition now and talk a little bit more about just some of the basics of the Constitution that'll help us understand what the intentions of the Constitutional Convention were. And I'm going to go over this pretty quickly, this next part, in large part because I think it's information that you've learned in the past, going all the way back to high school, depending, of course, on the high school that you went to, but the sort of nuts and bolts of the Constitution and its basic governmental structure. And the first point to emphasize here is that when we look at the conflicts that emerged in the Constitutional Convention amongst the elite white men who created it, the first conflict that was confronted was a basic conflict between large states and small states. And that's large and small in terms of population, not necessarily geographical size. Because there was a fundamental disagreement at the Constitutional Convention about whether or not states with large populations should have more power in the government that was being created in the Constitution versus states with smaller populations. And the way in which population was translated into power and the discussions that were had around these, the differences between large and small states basically broke down to two. One was in terms of representation. Should a national legislature that would be created in the Constitution have a larger representation from the larger states? Another way of saying that is, should states with larger populations have more power through a national legislature, or should it be balanced? Should the states have an equal number of representatives regardless of their population? And you can probably guess where the delegates from large and small states stood on this question, as generations of textbooks, and as Alan Taylor note, delegates from Virginia in particular, James Madison and Edmund Randolph, most importantly, Virginia being the largest state, pushed very hard for a proportional Congress, meaning that they believe larger states should have a larger say through more representation than smaller states. And that makes sense. They came from a large state in terms of population. They thought that larger states should have more representation. Whereas delegates from smaller states, and usually New Jersey is used as the most significant example, New Jersey being a small state in terms of population, argued for a more equal representation. And there are several quotes on pages 376 and 377 that attest to this. Virginians proposed a Virginia plan, which would have a proportional representation. As Alan Taylor notes, as generations of textbooks have made clear, the Virginia plan proposed a powerful national government, an inversion of the Articles of Confederation, in which larger states would have more sway over government action. And that makes sense, right? Knowing that Virginia was a large state. A counterplan called the New Jersey Plan proposed equal representation in a legislature and proposed to increase the powers of a potential national government, but not to the extent of the Virginia Plan. So the New Jersey Plan sought to find a middle ground between the Articles of Confederation and the Virginia Plan. And so out of these two plans, much of the structure of the Constitution was debated and ultimately created. This led to, for example, the implementation of a two-house system of Congress, the one that continues to exist, as you all know, a lower house, less powerful house, the House of Representatives, which is which is apportioned by proportion of population. There we go. Larger states in population have more representatives. That's still true today, of course. New York State has the third most representatives. Texas, the second. California, the first. Smaller states, Wyoming, the Dakotas, have fewer representatives. And an upper house, more powerful house, the Senate, whose members serve longer terms, 6 years versus 2 terms for representatives, and where each state is proportioned equally. As you sure know, each state has 2 senators, regardless of their size in terms of population. Other debates that were had sort of rising out of the differences between the New Jersey Plan and the Virginia Plan, and these I'm just going to talk very briefly about because I'm sure that you're familiar with them, had to do with the way in which powers would be apportioned between the different branches of government. The 3-branch system was pretty quickly agreed to early on in the proceedings of the Continental Congress, or Constitutional Convention, Constitutional Convention. And it's the basic system that continues to exist: a legislature, Congress, a judiciary, the nationals, ultimately Supreme Court and U.S. district courts, and the executive branch, 3, aka the president. The question was how do we create a Republican system with 3 branches of government, in the case of the Constitution, with a more powerful government than was the case under the Articles of Confederation, but how do we prevent one branch of this government in the future potentially from accruing too much power within itself, and that branch becoming a tyrant to the other branches of the government and ultimately to the citizens of the United States. And the big fear was how do we prevent the executive branch, the president, from accruing too much power in the future in some unknown possibility or possible scenario in which a president could center so much power in themselves that they might function as a king would. A real fear of the Constitutional Convention, a fear that makes sense when we think about the larger context of the post-revolutionary period. A similar fear was that Congress, the legislative, could have ultimately too much power accrued to itself, but especially that Congress could come to be controlled by a faction, by a political party that might use its power to pass legislation that was contrary to the interests of the people. And the people formally meant white men who were enfranchised, had the right to vote, which, as we noted in the 1780s last week, was only about 30% of the population. Still, how do we prevent the executive and the legislature, most importantly, from accruing this power? The solution, it's usually referred to as checks and balances system now, that each branch of the government has a check on the power of another. So I'm not going to go through those in detail because I think you've probably learned about those already, like presidential veto, Congress can override the presidential veto, et cetera, et cetera. So this was important, and certainly in the debates between the Virginia plan and the New Jersey plan and the creation of this federal structure, one could say is the most important achievement of the Constitutional Convention. It created the basic blueprint for the United States government. And that's really what the Constitution is. It's not a series of laws. It's not legislation at all. It's a blueprint for government, which is why, for example, when you read the Constitution, it's relatively brief. It is in 7 articles, meaning 7 sections, most of which are quite brief. And it's just, again, laying out a structure that would later need to be put into place, and that's what we'll talk about next week. So even though it's brief, and even though many of the sections of the Constitution are somewhat vague on specific powers that each branch of the government held, still an achievement to create a more powerful national government, a government that could tax, for example, as is provided in the Constitution, a government which could regulate commerce, also provided for in the Constitution, a government which could raise and maintain a standing army, provided for in the Constitution, a government that had an executive branch of president, all things that were not a part of the national government under the Articles of Confederation. The Constitutional Convention effectually succeeded in their overall goal. How do we create a stronger, hopefully more stable national government? Aside from the question of representation in the debate between large states and small states, to me and to, I think it's fair to say, most other 21st century modern historians, the biggest question, the most significant question, both at the time and in the long run, and the question which had the biggest possibility of derailing all of the proceedings at the Constitutional Convention, the one thing that was most difficult to compromise on was the question of slavery. How should this institution be included recognized in the government structure that was being created, the blueprint of the Constitution. And as you might expect, and as I hope to make clear, this was a tremendously divisive question. Why? Well, I'll return to a discussion we had a few weeks ago. The paths, the future of slavery in the different regions of the United States was beginning, as I fix my hair, beginning to diverge. And that most importantly is recognition of the fact that the northern states, New England and Pennsylvania in particular, as we discussed a few weeks ago, had already begun the process of abolishing slavery, right? Gradual emancipation. So their trajectory with reference to slavery was very different from the southern states, the states from Virginia and Maryland and farther to the south, states which did not gradually emancipate slaves, but states in which, more importantly, slavery not only continued to exist, but only would grow more important as a social, political, and certainly economic institution. So in one half of the country, slavery is being phased out. In the other, it only is becoming more important, and therefore slaveholders are only becoming more powerful. And as I mentioned earlier in this video, we should remember that 25 of the 55 members of the Constitutional Convention were slaveholders. It's just something that we should always have in the back of our mind when we discuss slavery in the Constitution. And so with reference to slavery, and you can open to page 379 through 383 in Alan Taylor's American Revolutions. I'll point to a couple of sections here, and then I'll scroll over and talk about the specific sections of the Constitution where slavery is discussed so we can see the actual language. Basically, there were two huge questions that the Constitutional Convention had to address with reference to chattel slavery. The first was the question of whether slaves would count as people in the United States, people recognized under the Constitution for the purposes of representation. Should slaves count as people in counting up population, which would determine the number of representatives in the House of Representatives, or should they not? And the second question was about the future of the slave trade, the future of American participation in purchasing and importing slaves from outside the United States into the United States. So that's the African slave trade, American ability to purchase slaves along the African coast and import them into the United States. But that also included the ability of United States citizens to buy slaves in Caribbean islands, for example, elsewhere in the Western Hemisphere, and bring them into the United States. So those are the two main questions, representation and the slave trade. But before I get into those and a couple of other portions of the Constitution with reference to slavery, one thing to make extremely clear at the outset of this discussion, before we get into these individual questions, is a point that is very, almost always often lost in modern discussions of the Constitution. And it's very important because if we don't have the basic understanding, which I'm about to give you, the areas in which slavery is discussed in the Constitution will make zero sense. And it is this, and I want to be very clear. There was zero possibility, no possibility, that the government, that the Constitutional Convention was in the midst of creating on paper in the Constitution, that would eventually be created after the Constitution was ratified. There was no chance that that government would have the authority to make slavery illegal in an individual state. Impossible. So much so that the possibility that the national government, this more powerful national government, could make a state abolish slavery was not once discussed. It was an understanding that everybody who came to the Constitutional Convention had, whether they were slaveholders or not. This government can't make a state abolish slavery. Just End of discussion. There wasn't even a discussion. Why? Because everybody at the Constitutional Convention knew, and they came in with one shared understanding, is that slavery as a legal system, of course it's a system of racial oppression, but as just a legal system, the law of slavery is something that the individual states create, not the national government. It's very important because the history of slavery in the United States, from this point, the creation of the Constitution, forward all the way to the Civil War, even though we won't get that far in this class chronologically, is rooted in that basic understanding. And it's something called, that modern historians call the federal, as in federal government, consensus, 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 yes. That slavery as a creature of law is something that the states either make legal or make illegal, which, as I just discussed and as we talked a couple of weeks ago, some states in the Northeast had begun to do. That is very important to note because sometimes you'll hear modern commentators all the way till today, and this is true especially of the 1619 Project. If you're familiar with that, I've referred to that in class. A recent project by the New York Times, a sort of popular history of slavery in United States history, will say things to the effect that the United States has been flawed from the very beginning because the Constitution did not allow the nation to abolish slavery. And the reason for that is that it wasn't even a discussion, okay? It's very important to remember because at no point was that even considered to be a possibility. If the state wants to make slavery legal, it can. If the state wants to abolish slavery, it can. That also helps us make sense of the areas of the Constitution where slavery does appear. And so let's get into those now. So there are three specific sections of the Constitution where slavery is addressed, but as Alan Taylor notes and as generations of historians since emphasized, the